Good morning, Counsel.
Good morning, Justice. May it please the Court. Robert Keegan and Cheryl Kimball on behalf of Fitchburg Gas and Electric. This is a case where the Department of Public Utilities imposed a financially crippling penalty on Fitchburg Gas and Electric, equivalent to 5 times the company's annual net income. That's 5 years of earnings from the company's gas operations, based on a finding that the company should have had pre-approval from the department for gas purchases that it made in 2007 and 2008. But there isn't a statute, a regulation, or a department rule that provides for a gas utility to have pre-approval for its gas purchases. The sole basis for the department's decision was an October 2002 case, DPU 01100, that by its explicit terms provided that if a gas company adopted a risk management plan that provided for it to trade in financial derivative instruments, it was required to come to the DPU and get its approval to trade in those financial derivative instruments. It specifically excluded traditional risk management practices of utilities involving the purchase of gas to put in storage before that gas was used, and forward purchases, that is, locking in prices for gas purchases during the year before the gas was delivered in the peak period.
Explicitly? You say explicitly?
Unambiguously and explicitly on page 2 of that order. And in fact, the department found in the case below that none of the company's purchases in 2007 or 2008 involved the trading of financial derivative instruments. And therefore, that order from October 2002 did not establish a requirement for the company to receive pre-approval of its gas purchases.
Let me ask you, go ahead. I guess I'll go. Let me ask you, did the company engage in those kinds of purchases, the storage purchases, those traditional methods that you speak of, and the futures contracts, prior to the order in 01100A?
It did, but I just want to correct the word futures contract. The company never engaged in futures. It had a contract to purchase gas, and it has the ability to either purchase gas on the day it's going to use that gas at spot price, or any other purchase is saying to the supplier, I want you to deliver me 100 units of gas either later this month at the first of the month price, that's a forward purchase, or I want you to deliver me gas next January at the current price, the current market price established today for deliveries in January. So it only has 2 ways. And yes, the company did that a full year before the department's order in 2002. And it did it because a part of its normal purchasing decisions has to take into account the risk of fluctuations in the marketplace. And frankly, it would be imprudent for a company, given the industry practices and standards, to, in attempting to buy gas for its customers, not try to, given the level of volatility that started to occur in gas prices in 2001, spread out and average the differences in those costs by buying forward.
So I guess what I'm just trying to ask is, was the practice of the company consistent both before and after the order?
Yes, it was.
Can I ask you? Go ahead. I'm sorry.
You asked. You referred to the order, I guess we'll call it, as unambiguous, and I understand your argument because there is a definition that the department uses for what they call the kind of the new risk management, and they describe futures. And then the traditional method, which you describe as purchasing month of, or in some cases in advance.
Purchasing forward.
Right,
yes.
but rather than, you're not talking about options or any derivatives or anything like that. But, and I also understand that in the comments, the focus is on this new kind of risk management. But in fact, in the language of the order itself, it's kind of conflated. And the department says that it's going to be speaking in terms of all of these things when it talks about risk management. So isn't it ambiguous, at least?
I submit it as not, because the department specifically says and identifies traditional mechanisms are not really being addressed under the order. It
And
really,
yes, it does. And I pointed that out. But then when it goes on, there's also a definition, and it says, we're going to now talk about risk management.
yes.
And then they just talk about risk management.
But risk management is inherent in any decision a utility makes. And so I would say the obligation to purchase gas at the lowest possible cost coincides and exists simultaneously with the risk management decisions it's making. That goes to the issue of what is the appropriate standard to apply for, in the required legal standard, to apply in evaluating management decisions. And that is, I'm sorry.
No, I
want to make sure I answer your question.
You did answer the question to a point, but you said something else, and that is that your goal was to pay less. But the whole point since 2001 or 2000 was not to pay less, but to engage in different kind of risk management so that there would be stabilization of price, sometimes at the cost of paying less.
I guess what's the measurement of paying less? The measurement of paying less can't be an after the fact. Well, you bought this month, and later it turned out the gas price was lower or higher. The measurement of paying less has to be, did you undertake reasonable actions, reasonable and prudent actions at the time you made the purchasing decision? And that's really what the department has to evaluate. Were the actions on the part of the company reasonable when it undertook the decision? It wasn't that the company was trying to pay less or pay more. It was trying to put together, in a reasonable fashion, a gas portfolio that would minimize the risks in the price volatility. The company does not want, as the department suggests, to be in January when the winter turns cold and the price of gas goes through the roof, having to buy all of its gas in that month.
Isn't
Is
the
this
difference then whether you're engaging in cost reduction or cost stabilization? Essentially, it comes to that. If you're going to engage in cost stabilization, you need pre-approval.
The two coincide.
Not a fair statement?
That's not a fair statement.
Can I ask?
A normal part of attempting to buy at the lowest possible cost is to stabilize prices. The two exist mutually. They're not mutually exclusive. I'm sorry.
No, I want to get back to the test. Are you talking about the prudence test? Or
Yes.
is this, all right. The prudence test is not hindsight, or is there a part of hindsight to it?
No, it's not hindsight.
Not at all. I mean, oh boy, you made some bad bets and you developed
Well, it's not-
catastrophic situation for your customers. That has nothing to do with the prudence test. It's just looking at the time you made the purchases, were they
Yes.
reasonable?
Yes, because to hold the company to another standard, to make its decisions come out at the end to be right, to go to Las Vegas, I put down on 18, well, 18 didn't come in, that was an imprudent bet. It has to be on the basis of, and the case law before this court and the department has always been.
Well,
Take a
certainly
look-
evidence that your decisions were catastrophic may have some bearing on whether they were prudent.
Well, that's true, and the department should look at those decisions and on the basis of what the company knew or should have known at the time, make a determination as to whether that action was in fact prudent. Now,
Yeah, okay. You mentioned in here that, in fact, although there is, I don't understand where this $4.7 million figure, $4.6 million figure comes from. I honestly don't understand it. But you say if you actually look at what the department said other companies could do, or if you applied that to Fitchburg, they wouldn't have, there wouldn't be a $4.6 million gap here. They would be, actually may have been better off.
That's correct. Had the company, one of the findings of imprudence was you didn't do it like the other companies did, and you bought in increments and over a different time period than the other companies did. But the record clearly demonstrates that had the company purchased in uniform increments over a 10-month period in 2007 and again in 2008, its gas costs would have been $260,000 higher than they were. So for for not doing it exactly the way other companies had been doing it, which is not a measure of imprudence, frankly, the gas costs would have, in fact, had they done it that way, been higher than they otherwise would have. The jump that the department makes is it finds that the company was imprudent because it didn't have a pre-approved plan, a plan which I suggest was not required, because the company was never engaging in financial derivative instruments, and that's a totally justified interpretation of 108A. But because the company didn't have a pre-approved plan, the department, without any cites or references to prior cases or any statements in the past, pulled a standard out of thin air and said, in the absence of such a plan, you're required to buy gas at first of the month pricing. And why did it do that? Because it got them to the $4.6 million. It saddled the...
You had bought gas, first of the month pricing. During all of this, it would have cost you $4.6 million less.
That's correct.
So that's where
correct.
that number comes from.
And what the department did by arriving at that penalty, it took advantage of the rapid and unprecedented and unpredictable drop in gas prices that coincided with the collapse of the financial system in the United States in late 2008. Gas prices were a little over almost $14 in June and July throughout the summer, when all of Massachusetts gas companies were buying their gas for the next peak winter season. Because of the financial crisis, by December of 2008, prices had gone down to a little over $3. Well, none of the other companies had $3 gas in their portfolios.
So if they applied the same analysis to the other companies?
No. Had they applied the same analysis?
To the other companies?
They did not.
No. If they had applied the same
Yes.
analysis to the other companies, would they also have gotten a figure?
Huge, far larger than for National
4.6
Grid and
million.
NSTAR, far larger
So
than...
why were you doing something different than all the other companies?
Well, we
Did you
weren't-
know something that they didn't know? Or?
Your Honor, we weren't doing anything different than the other companies were buying gas in anticipation of the peak season in earlier months. Fitchburg was buying gas in anticipation of the peak season in earlier months. They were doing the exact same thing. There may have been minor differences between the time periods that
So why did you guys get singled out for doing this when everybody else was essentially doing the same thing?
because in a cost of gas adjustment clause hearing, all of a sudden the department said, oh, we never knew you were doing this, despite the fact that the company had disclosed its purchasing practices for the last 8 years in 3 load forecast and supply plans, which they file under Chapter 164, Section 69I, and they disclosed their purchasing practices, and they had the department's approval of every one of those 3 load forecast and supply plans.
But the position is, that from the department's point of view, that you didn't seek formal approval through a process that, you submit and say in advance, this is what we're going to do, is this okay? Isn't that a fair statement?
That's the department's
Okay.
position.
But, and your argument, as I understand it now, is, wasn't required, 2 arguments. One, it wasn't required, because we're not engaging in the kind of risk management that requires
That's
approval.
correct.
Secondly, if I understand it, if you had, if they were, maybe I'm rephrasing, is this what you're saying? If they're going to penalize you, then they shouldn't be imprudent themselves and hold you to a standard that would not at the time have been prudent, i.e. first of the month.
That's correct.
Okay.
And a standard that has never been articulated by the department. It's only been stated once, and it was stated in this case.
Okay. Let me play devil's advocate, perhaps AG's advocate. I expect to hear momentarily that the 01 decision essentially says once you begin to spend money for risk allocation above and beyond the price, then that is generally what's done in derivatives, and that what you folks did based on is that you spent more, that when they did their evaluation of your price, the price you paid was above the highest price for the day. So they say you essentially did something analogous to a derivative because you paid essentially a sum of money for risk allocation, and if you're going to spend a sum of money for risk allocation, that has to be approved by the department because the sum of money paid for risk allocation is contrary to the low price obligation.
That's a factually incorrect finding, and it's unsupported by the record. They made that finding on the basis of record evidence that they took after the record was closed, on the basis of a Platts publication. Now, the Platts publication is based upon a sampling of prices during a particular day, traded during a particular day. It does not incorporate all prices, and the company never paid a premium on any of its purchases. It paid for gas at the existing market price for deliveries for the month in which it was purchasing that gas. And it never paid any additional fee or charge. It paid only the market price that was in place. In the conclusion from, frankly, the Platts digest that we never really got a chance because it was taken into evidence after the hearings were closed, led them to a factually incorrect finding on that.
Let's assume that there's a difference of point of view. What do you say we should do if it turns out that it matters whether you paid more than the highest price? What should we do in view of what we have? We've got the findings of the DPU. We've got you saying that's unfair because it's based on facts that were taken as a matter of judicial notice or administrative notice after the fact. What should we do?
Well, I think that was a factually erroneous finding, but I don't think it's dispositive as to the ultimate outcome of the case, because the ultimate outcome of the case has to be based upon whether the company's decisions at the time it made those decisions were prudent. And in fact, they were prudent.
Okay, but let's assume for the moment that it is dispositive. What should we do in view of what we have?
I would say in that case, I suppose then there's a factual dispute, and the company would have to, on remand, go back and demonstrate that, in fact, based on a full sampling of prices from the market on that day, that the company's prices were within that range, and therefore it did not incur any additional charges, which it did not.
We're going to have to leave it there, sir.
Thank you very much, Chief Justice. With that, I'll rest on our brief.
May it please the Court, Assistant Attorney General David A. Guberman for the Department. There's no unfairness, Justice Gantz. The hearing officer gave notice to the parties of her intention to take administrative notice of the Platts data. The citations are at page 5 and 6 of our brief. Under the applicable rule, Fitchburg was entitled, if it made a timely request, to contest the taking of official notice. Actually, what Fitchburg did was to say it had no objection, but it wanted what it called a hard copy of the data so that all parties have the opportunity to review and verify the data being considered by the department. After Fitchburg received the data, it was silent. It made no objection. It made no request that it be given an opportunity to contest or offer a different interpretation.
But they have said, will say, I think, that, yeah, we don't claim that the data is incorrect. We claim that your application of the data is incorrect, and we didn't have an opportunity to challenge your application of the data.
They had an opportunity to provide whatever explanation of the data they thought appropriate. The department engaged in what it always...
You didn't tell them why you were using it. You didn't say that you're using it to see whether or not they paid above and beyond prices, did you?
I would have to check the record to be sure, but even if the department did not, the department as fact finder is free to look at the facts that are in evidence, and if the evidence before it supports the finding that it makes, then that is substantial evidence, and this Court is obliged to defer to the department's finding of fact. With respect to Justice Cordy's question of where the $4.6 million figure comes from, the figure comes from comparing what the company actually did with what other companies actually did, namely the other companies, Berkshire and others, that not having approved price volatility mitigation plans used traditional purchasing practices.
Well, I'm sorry, a lock-in is a traditional purchasing practice, is it not?
It is a traditional purchasing practice when used for filling storage tanks. It is a traditional purchasing practice when it's part of a strategy of trying to achieve the lowest possible cost. It is not a traditional purchasing practice when it's part of a plan that, rather than seeking the lowest possible cost, is seeking to mitigate the volatility in prices.
I'm very confused about that. I mean, you say these are completely incompatible, stability and lowest cost. In my experience, that couldn't be further from the truth. They're not always perfectly incongruence, but they are compatible. Indeed, they're the tool that lock-ins you use to try to create both stability and low cost.
Well, with respect, Your Honor, no, they're not. There is a trade-off involved, and I think it can be explained. We've used the analogy to dollar cost averaging, but let's look at what happens with the sort of plans that were proposed and approved by the department.
Now fine, but let me ask you this. You say you figured this $4.6 million by looking at Berkshire, which did what? Purchase first of the month thing?
They purchased a certain amount for storage, and the balance was purchased either in the spot market or first of the month.
Did you look at National Grid and NSTAR, who had approved plans, to see if they had used the Berkshire technique, they would have done better than they actually did?
No, Your Honor, they were
not?
not relevant.
Why not?
They're not relevant, Your Honor,
Because they were approved? Therefore, if they're completely imprudent, it's not relevant?
They weren't imprudent.
Why not?
They weren't imprudent because imprudence looks to two different things. One is the purchasing program or practices in which the company is engaged itself imprudent? The department found that Fitchburg's purchasing practices were themselves imprudent. For example,
imprudent not because they weren't approved, but imprudent in some objective manner.
Yes, for example, in the 2007-2008 heating season, compressing all of the purchases into a 9-week period.
All right. Now, I'm going to go back to NSTAR and National Grid,
Yes.
who did have a, quote, approved
Yes.
risk or stabilization
That's
plan.
right.
And you didn't find out how they would have done if they had done what you say Fitchburg would have done.
Because their plans were approved, by definition, it was not imprudent of them to implement a plan that had the department's approval. So then there's the second question, which is, given a prudent plan, has it been carried out in an imprudent manner? For example, you might have a plan. Fitchburg had written guidelines for the 2008-2009 season that called for purchasing over a 10-month period in equal increments. In fact, it purchased over 7 months in unequal increments. So if we look at NSTAR, if NSTAR deviated from its plan, that might lead to a conclusion that it was behaving imprudently. Here, we can see that not only was...
Well, it might or might not.
Might or it might not, depending on the facts that were known to NSTAR at the time it made its decision to deviate from the plan.
And is that what you did? You went back and looked at Fitchburg to say, at the time you made these decisions, were they imprudent, weren't they imprudent? Or did you say, well, they deviated from the plan, therefore they were imprudent?
We did three things, Your Honor. First, the department said that the plan, for 2007-8, it would be a bit much to dignify it by the name of plan, but we said that the purchasing practices themselves were imprudent. And then the department also found that the conduct of the company was imprudent. It was imprudent in November of 2008, after the start of the heating season, and contrary to the company's plan, to buy a substantial amount of gas for the months of January through February. And it was also not an effort at price mitigation. The company's own witness testified that the reasons that the company did this in November of 2008 was because it looked at market indicators, it looked at weather forecasts that said below normal temperatures should be expected, it looked at the fact that prices having gone down and it thought having reached a bottom, it could save money on the average cost of gas. And so, like a gambler on a losing streak...
Oh, I don't know. All those factors sound pretty prudent to me.
All of those factors sound prudent if what you're engaged in is an attempt to get gas at the lowest possible cost.
And to get gas at the lowest possible price and to stabilize the cost.
Well, no, Your Honor, because stabilization involves buying over an extended period of time without specific attention to whether the prices are going up or down. Here's the thing.
If Fitchburg had submitted a plan which contained the details which hoisted them on their own petard, if they had submitted a plan with those details to the DPU and sought approval, do we know that the DPU would not have approved such a plan?
We don't know one way or the other, but we do know this. We know that the shortest purchasing period that the department did approve was 12 months. And we know that Fitchburg's written guidelines called for 10 months, and in a submission that it made...
Why couldn't they change that in light of certain circumstances, bottoms falling out of the market, things like that?
In one of the submissions that they made, and I believe it's cited in our brief, Fitchburg said that because of its small size, it's either the smallest or the next smallest distribution company in the Commonwealth, that it might not be able to purchase a sufficient, there might not be a seller willing to sell it a volume of gas that it could buy in equal 12-month increments. So Fitchburg very well might not have been able to submit a plan that the department would have approved. But what we do know is that it had an obligation not to engage in price stabilization without the department's approval. This court said...
But that gets back to Justice Cordy's question. Okay, so what was imprudent about what they did? Even if they... I mean, they could have gotten approval for a plan that would have been terribly imprudent, and that would have saved them. They didn't do that. And now we look at the merits of their plan. It doesn't sound like what they did was that bad.
But prudence is not something that we look at in hindsight. And this is why, if we look at NSTAR with, or a better Keyspan with a 12-month plan, so that in the first month they buy on, 2 different fixed days during the month. And in February, let's say it's January. In February, the price goes up. And they can decide, if they don't have a plan, well, the price is going up, maybe I'll wait, and in March I'll buy more because the price might come back down. And they make these decisions based on trying to figure out what the market is going to be. And sometimes their prediction works out, and sometimes their prediction doesn't work out. But what they are trying to do is essentially to get the lowest possible price for gas. That is not a price mitigation plan. A price mitigation plan says, I'm going to buy 1/12 in the first month, 1/12 in the second month, and prices may go up and down. I am going to get the average. That's why price mitigation is in tension with an effort to get the lowest possible cost, because price mitigation does not look to the market price on the day or in the month that the purchase is being made. That's the essential difference.
So the only plans that need approval are stabilization plans?
Any plan,
where the focus doesn't focus, just to summarize, on trying to reduce costs, but trying to stabilize.
Price stabilization plans need approval, but they're not the only ones.
I'm sorry. Would a price stabilization plan need approval if it only used a physical gas purchases and forward contracts? It's a yes or no.
The answer is that if the aim is price stabilization, it needs approval. That is not what was involved.
Even if the means of price stabilization is purely physical gas purchases and forward contracts?
Buying physical purchase for storage has a stabilizing effect, but that's not the reason that companies engaged in buying gas for storage. A company needs to have a supply on hand in order to provide an adequate supply.
Try my question. It's a precise question.
I'm sorry, I thought I was answering it.
I don't think you are. If there is risk management that uses only physical gas purchases and forward contracts, is it your position that that requires the advance approval of the department?
If the aim of the purchasing program is risk management, then the answer to your question is yes, but that's not this case.
And how can that argue? I mean, a distinction should be page 2, which is, I thought, was the whole crux of this case. A distinction should be made regarding traditional forms of risk management, which include the use of storage to offset winter demand through the use of physical gas purchase and forward contracts, and modern risk management functions. And I thought it was quite clear that only the latter requires advance approval. You're saying that's not right?
I think what the department is saying in the order.
Well, show me where it says it. Don't tell me what you think it says. Show me where somebody can read it and say that's what it means.
I think looking at the order in isolation, Your Honor's reading of it is entirely reasonable. But I think that there is a broader context of which Fitchburg and the other companies were fully aware, and that's why Keyspan, NSTAR, and New England came in and requested approval consistently with the order, even though they weren't using any of these modern risk management techniques. That the companies understood that the baseline prior to the 01-100 case was if you were going to do anything beyond trying to get the lowest possible cost consistent with securing an adequate supply, which is why you have purchase for storage, you need to come in and get approval. This court said in an earlier case dealing with Fitchburg, the 2004 case, that consideration can be given to the department's long administrative understanding and practice. And the department has made clear that since its inception in 1919, least cost acquisition of gas for utilities customers is a departmental requirement. It said it in the gas unbundling case only a short time before these events took place. It said it in this case consistently with those decisions. The other companies understood what the requirements were. For Fitchburg to be right, all the other companies in the Commonwealth have to have been imprudent. And
So you're saying that if risk allocation, even if risk allocation does not cost anything above and beyond the price paid for the natural gas, you still require the approval of the department?
Yes, because you are putting at risk the ratepayers' entitlement to the lowest possible cost of gas. And the department concluded that given the unusual circumstances beginning in the winter of 2001, that price stabilization was an acceptable trade-off if it was part of a plan that was presented to the department for approval. That's what happened in the Keyspan, NSTAR, and New England cases. The department was presented with proposals that did not cost anything beyond the normal price of gas.
How did the department respond to Fitchburg's claim that, look, we're too small a company to be able to buy 1/12 of our gas requirements each month over a period of a year? We had to bunch it up. How did you respond to that? How did the department respond to that?
Well, Fitchburg has pending before the department a request for approval for, I believe, such a plan, and that is under advisement, and the department hasn't answered it. What the department did say was that a 7-month purchasing period is too short. That's 3 months shorter than Fitchburg's own purchasing plan. So Fitchburg represented in its purchasing plan, if you will, that it could do it over a 10-month period, and nevertheless it compressed it into a 7-month period for one winter, and for the preceding winter it did it over a 9-week period.
Chief, can I ask another question? I'm sorry. Justice Spina, do you have a follow-up?
No.
You say that the Keyspan and the NSTAR proposals did not involve, I mean, that somehow they didn't involve, let me take that back, that their proposal should have demonstrated to Fitchburg that they also had an obligation. Now, Fitchburg says the proposals submitted by Keyspan and NSTAR involved the use of financial instruments to effect price locks, and their proposals were explicitly made pursuant to the department's ruling of 2002. Is that just wrong?
It is wrong, and we in our brief, with citations to the record, explain exactly how it's wrong.
Okay, this was in their reply brief that they.
Yes, but they don't deal with the record references or explanation in our brief. If you want me to take the time, I can
No,
walk
I'm
you
just
through
asking you,
it.
if you say they're wrong, then we'll look to see if
They're wrong, and our brief will demonstrate it. Thank you, Your Honors.
I don't know. What's next?
Farrell.